So I'm just going to introduce myself. I'm Ryan von Ruben. I'm an architect. I'm registered in South Africa and in the UK, but I'm also a qualified mediator as well. And then Adrian Kennedy from Everingham's is an attorney and will be joining us for the Q&A afterwards. And Marion Shea is a director at Conflict Dynamics, which is a firm that specializes in the training of mediators and also providing mediators for disputes. And she will be joining us for the mediation, for the Q&A panel afterwards as well. So I'm just going to launch right into it. If I can get, aha. No, I'm not. There we go. Okay. So the sections I'm going to cover tonight are the risks of dispute in general, in case you weren't already acutely aware of them. Mediation and construction. So there's two types of mediation, and I'll just talk briefly about the differences between the two. The benefits of mediation, what happens in mediation, when to mediate, how to get to mediation, and then the kind of summarizing what the CIFA mediation clinic will actually be. No, it's not working. Oh, there we go. So in terms of what mediation is, it's fast, it's inexpensive, and it does have a 92% success rate across all industries. And from a South African context, it's also about to become mandatory. I'm struggling with my pointer here. Excellent. So on the 22nd of April this year, the Gauteng Division of the High Court, the Judge President, introduced a protocol and a procedure in the High Court which made mediation mandatory. So you won't actually be able to get a court date for a matter before the High Court unless you have a mediator's report which basically confirms that you've made a good faith effort to engage in mediation before coming to court. The reason that they did this is because the court rolls had become unacceptably long. You were basically having to wait until 2031 in some cases to get a court date. So for and these are obviously only for commercial matters, civil matters. But basically it's a massive change because before mediation was a tool that the court used, but only under very specific circumstances. And this has meant now that mediation is it's a massive change and a broad kind of sweeping approach to the use of mediation, the mandatory use of mediation in the courts. So it's not the case in the Western Cape yet, but depending on how the trial unfolds in Gauteng, it may well become something more general. So to talk about the risks of dispute, I just thought I would start with a case study, which is a project. It's a construction project that's quite well known in kind of UK legal circles. And it hinges around a couple who, Elizabeth and John Bullard, like many couples, they decided that they wanted to enlarge their home. And so they engaged the services. They did everything the right way. They had plans drawn up by an architect, got planning permission, engaged a QS to administer the contract, and appointed a builder who was very reputable, well-known, not a bucky builder, the best builder that they could find in their local area. Entered into a building contract using a standard contract form on the basis of not a huge contract, so about £90,000. And they arranged for 4 equal payments in installments of about £14,000, 13.5, £14,000. Project went fine up until the third invoice that the builder issued, at which point they decided to withhold payment, saying that they weren't happy with some of the work. And basically, from that point onwards, they kind of entered into a dispute. The builder wouldn't back down, they wouldn't back down. Fast forward 5 years, they went through the appeals court, they went through up to the kind of highest level of the courts that they could go to, apart from going to the House of Lords. And the long and short of it is that so John Bullard, one of the clients, ended up in hospital with medical issues. The builder ended up in hospital with a heart condition, and on the final day of deliberations, it was like one of those scenes from a movie where there was just carnage in the courtroom because there were tears and wailing and gnashing of teeth. Because what happened was the judges reversed an earlier decision where the issue wasn't so much in terms of the award of the claim. In fact, that was awarded to the builder, although reduced from his original claim of 13,500 to only 5,000. So he won his claim, but the issue was on costs, because originally the courts had ruled in favor of the Bullards and had awarded them costs for the trial. And the builder had appealed those costs, or the costs award. And so in the High Court, he was vindicated, and the judges basically came to him, which meant that the Bullards were left with to pay his costs of over £250,000. So in total, the court case cost them about £400,000. During the duration of the court case, they were unable to finish construction on the house for various reasons, which then meant that they had to mortgage the house to pay the legal bills, but they couldn't mortgage the house because the house was not mortgageable because it wasn't finished. So they basically faced financial ruin, and all because of the initial claim of £13,500 wasn't even the principle of the claim. The principle of the claim was some of the 13,500. So they basically, in their judgment, the justices kind of said that there were two distinct occasions when mediation was offered by the builders' legal representatives, and where the Bullards refused mediation. And so they gave that as a very specific reason as to why they decided to reverse the costs award, because they felt that they'd unreasonably refused mediation. So it all could have been resolved much more easily, but in the end was not. So the main types of risk that you get when a dispute arises, so just kind of extrapolating from that example, the main types of risk are direct costs, your legal and professional fees, productivity. What the stuff that you're doing in your office at the time goes out the window because your attention gets pulled onto this dispute. Your performance, even if you can work on other stuff, your mind is not there. You're not on top of your game. Relationships, so your threats to your ongoing and future working relationships. It's not easy when you're in dispute with a client to carry on with the project. And then if other clients come to hear about it, obviously that can take a toll on those relationships as well. Emotional, it's obvious: stress, anxiety, and resulting health issues. You've got two men who ended up in hospital over a 5-year period from a court case. Your reputational damage, impact on the workplace. If you have staff working for you and there's this uncertainty about a looming dispute, that creates all kinds of problems of its own. And then what's interesting is that the actual true cost in kind of rands and cents of disputes, there was some research done in the UK where they worked out that in a single year, conflict cost UK businesses about 800 billion rand, but only or less than 20% of that cost went to lawyers' fees. So the actual costs of dispute, people sort of think immediately that most of the costs of dispute are on the sort of the people that you pay to solve it for you. Actually, it's that loss of productivity, which is the largest factor in terms of the cost of a dispute. So the other thing to keep in mind is that what's even worse is that in a construction context, the cumulative risk is amplified by the time taken to resolve the dispute. So In construction projects, the problem is that if a dispute arises early on and causes the project to stop, you get this rapid accumulation of costs. So in construction projects, disputes can be even more dangerous and even more costly because of that link to time. Specific risks due to a lack of control. So there's also this idea that when you litigate or when you refer disputes on to kind of formal procedures, as a party to the dispute, you lose a lot of control in terms of how that dispute is going to be resolved. Often it's really the amount of money that you're willing to spend that will determine the outcome. So if you can afford the best expert witnesses, if you can afford the best attorneys, that will have an effect on the outcome. Insurers and lawyers will be driving the process. So they are the people who are covering the costs or who are liable for the risk. Insurers will want to drive the process. Even if you win legally, you can still lose commercially. You can get a positive result, but all of that lost time and productivity can mean that you're actually worse off than you were at the beginning. Results are win-lose and are often all or nothing plus costs. When a judgment gets handed down, the judge will award the claim or will refuse the claim. And so a judge is not going to sit there and go, well, you can make, it's seldom where they will take a very nuanced approach to deciding what to award and what not to award, unless the claim is broken up in that way. So often you will get all or nothing, and then there's also the issue of costs. So you get a double whammy. It's only decisive when the losing side is out of options or out of money. If somebody's got deep pockets, they will string that dispute on as long as possible if they don't get the result that they want. So if you don't have deep pockets, you will be at the mercy of how long can they afford to keep it going until they get the result that they want. Decisions become a matter of public record, which do pose risks to reputation. So all court judgments in civil matters, we've got to be careful, all judgments get made public, a matter of record. Yeah, so there is this issue of once it's out there in the public domain, there's nothing you can do to stop it. So that just gives you a kind of a graphic, as architects, we love pictures, so there's a graphic that just kind of shows you over time how those cumulative risks build up in terms of, so you've got your direct costs, your productivity, performance, relationships, mental well-being, workplace morale. The longer a dispute drags on, the bigger the risks and the higher the cost. So what about arbitration? So even though it has many of the same risks, arbitration is seen as better than litigation because it's supposed to be faster, it's usually less expensive, and there are limited avenues for appeal, so the decision is final, kind of. And the result is confidential. Unless there's an appeal, the result is made in order of court, in which case the findings can actually become public. So arbitration is mostly better than litigation because it's quicker. And so you don't get that same kind of increase of risks that you would do in litigation. I attended recently an international construction law conference in Cape Town. There was an international construction arbitrator who was presenting a paper. And he opened his talk by basically with this sentence. This was his opening sentence: arbitration should be avoided if at all possible. So if you've got one of the world's leading construction arbitrators saying that arbitration should be avoided if at all possible, I think that's sending a pretty strong signal about the relative risks of arbitration. And that just, again, kind of compares, you've got the sort of the line of litigation, the risks in litigation, and arbitration. So arbitration, because it's much shorter or a shorter time period, does have reduced risks, unless, of course, it goes to appeal or it gets disputed afterwards. So this idea of facilitative mediation and evaluative mediation. First of all, the kind of definition of mediation. This is a very dense definition. It's given by the Center for Effective Dispute Resolution in the UK. And it's seen as the kind of the almost like the definitive definition of what mediation is. Mediation is a flexible process conducted confidentially in which a neutral person actively assists parties in working towards a negotiated agreement of a dispute or difference, with the parties in ultimate control of the decision to settle and the terms of resolution. Super dense. The key things to focus on are flexible, so it's a flexible process. It's confidential. The mediator is a neutral person, and the mediator's role is to assist the parties to negotiate an agreement which they develop. So, and ultimately the parties are in control of the whole process. Why that's important, and this is, I think, kind of a definition which is a definition of what facilitative mediation is, as opposed to evaluative mediation. So the key characteristics include flexibility, confidentiality, neutrality, party autonomy, and interests and not rights. And I think it's that last point that's kind of key to facilitative mediation, is that facilitative mediation is very much about identifying the needs and interests that underlie the dispute, or the parties in dispute. So legal arguments are about your legal rights or your contractual rights. Whereas when you're mediating and you're negotiating, you're trying to get at what the interests or needs are that are underlying those. What was driving you to have that commercial relationship in the first place? So what needs did you have when you entered into that commercial relationship? What were you trying to achieve? Not so much focusing on what are the rights that you're entitled to by the terms of the contract. So in terms of the kind of range of types of alternative dispute resolution, or general dispute resolution, you've got kind of consensual, recommended, and imposed. And consensual, at the one extreme, you've got negotiation, which is the kind of dispute resolution that we all do every day without any help from anybody. And at the other extreme, you've got litigation. And in between the two, you've got a whole range of stuff, and a lot of them, you know, we kind of recognize in terms of adjudication. There's an ombudsman, there's a mediator recommendation, ARB-Med, there's like sort of quite sort of arcane stuff. But the interesting thing is that you've got mediation over here. This is facilitative mediation. And then when there's a mediator recommendation, that's evaluative mediation. So evaluative mediation is kind of much more towards the center of those extremes, whereas facilitative mediation is much more towards the negotiation end. In terms of the main differences, so facilitative mediation is what is generally used throughout most commercial environments. Evaluative mediation is something which, for some reason, it's not entirely clear why, but in the South African construction sector, evaluative mediation is what seems to have become the most pervasive form of mediation. RICs tend to promote evaluative mediation, and a lot of people describe evaluative mediation as arbitration light. So the idea being that the role of the mediator is not only to try to help the parties reach agreement, but he's also there as a kind of third party, almost an expert, to provide a recommendation at the end of the mediation on what a sensible agreement should look like. The difference, though, is that because the mediator is providing a recommendation, what that can do to the kind of chemistry of the negotiations and the process is that the parties will spend their time trying to convince the mediator of their positions. They won't spend that energy trying to engage with each other, because in facilitative mediation, the mediator is not there to say who's right and who's wrong. In facilitative mediation, the mediator is just there to provide the framework and the process to help people find common ground and to find a solution. So if you're kind of in an environment where you know that ultimately at the end of this process, somebody is going to come down and say, this is who's right and who's wrong, you're not going to open up. You're not going to reveal everything that you need to, because that might put you in jeopardy. So it's a fundamentally different approach. And I think often people say that facilitative mediation is a process-focused approach. So it's very much about how you go through and deal with the issues, whereas evaluative mediation is an outcome-focused approach. You know that there is going to be an outcome whether you reach agreement or not. And that, I think, is probably why people have gravitated towards that kind of mediation, because they see it as a quick form. Again, it's sort of arbitration light. You're very quickly going to get some kind of indication of who's right and who's wrong. But facilitative mediation is not necessarily about who's right and who's wrong. It's about finding a way forward for both parties, regardless of who's right and who's wrong. It's about finding a commercial solution that is agreeable to both sides. Yeah. And it's interesting that in that Gauteng division of the High Court, it's actually facilitative mediation that is specifically endorsed. So they make reference to facilitative mediation, not to evaluative mediation. And I'll come on to a couple of things later. So the benefits of mediation, again, just in case you didn't reach the first time, 92% success rate, it's fast, it's cheap, and it's also very easy. So what do I mean by fast? Mediation is significantly faster than other dispute resolution processes. It can be arranged within days. So you're not having to wait months for an arbitrator. You can get a mediator within days, and at times in venues convenient for all parties. It's much more flexible. It typically takes 1 day or less for the mediation. And even without agreement, the process can accelerate later arbitration or court proceedings. And that's because in the process of mediation, you can actually narrow the scope of dispute. You can find where you've got common ground. So you can basically say, right, we agree on these issues, but we just can't find a way to agree on those issues. But because you found common ground and you can narrow the issues, which means that anything that then gets referred for arbitration or litigation can be resolved much more quickly. It's much less complex. So it's cheap. A lot of that is linked to the time that it takes, right? So in terms of preparation, there are no real written submissions. You don't have to make written submissions. You can do, and I think a lot of attorneys would prefer to do some of the preparation work that they would normally do so that they've got all of their kind of ducks in a row, but it's not always required. And especially where you've got certain kinds of disputes that are not necessarily contractual disputes, you don't have to spend a huge amount of time preparing for the mediation. Hourly rates, the cost of a mediation typically ranges between 10,000 and 25,000 Rand for a full day and usually includes the venue. Many disputes can be mediated in less than a day, in half a day. Legal fees, whilst you can be represented by lawyers at the mediation, it isn't a requirement, which can further decrease costs. I think what's key about that, and I'll touch on it later as well, is that, again, for some reason, in a lot of evaluative mediation, and particularly in contract clauses that refer to evaluative mediation, they actually don't want you to have legal representation because they feel that it will slow down the process and it will, and that the lawyers will somehow start to control the process. But in facilitative mediation, we actually encourage participation of lawyers. We want lawyers to be part of the process because there's two parts to the mediation process, which I'll talk a little bit about later. But there's this thing called reality testing that happens in the mediation, where when you're developing solutions with the disputing parties, what you have to do as a mediator is say, well, what is the worst case scenario? What will happen if you don't agree? And it's really good to have a lawyer sitting next to them to say, well, if you don't agree, this is how much it's going to cost you in legal fees to go all the way, right? So lawyers can really help to bring perspective about what the worst alternative is if you don't reach an agreement. The other reason why it's really good to have lawyers involved is because when you do get to an agreement, you have to put that down in writing. and to have a lawyer there who can help you craft the language to make sure that the agreement that you've put in place will actually cover all the issues that you need resolved. So that's just a kind of, again, very dense, maybe something to look at afterwards, but it's a spreadsheet that's been put together by an attorney, Patrick Deal, during a conflict dynamics seminar, talking about the cost of litigation. Not only the cost, but also the risks. And what's quite interesting is that basically what I think a lot of people don't realize is that obviously litigation happens in stages. And what you can do is you can go through all of those stages, incur all of those costs. The vast majority of cases are, there's this expression in the legal community where they talk about the steps of court, right? So you agree terms on the steps of court. And the vast majority of cases are resolved or settled on the steps of court, which means that you've gone through all of that process. You know, you've gone through your informal resolution, your pre-litigation, your pre-trial pleadings, and then just as trial is about to start, you settle. So you've gone through all of that time and all of that expense only to settle, in other words, to negotiate terms which you could have done all the way at the beginning. And the reason why that happens is because no attorney will guarantee you an outcome in court. The legal system is too difficult, or the systems at play are too difficult to predict. It's very difficult to guarantee an outcome. So even if you have a surefire case, you might not win, right? So that's why that kind of that idea of being able to resolve issues up front rather than going all the way only to do what you could have done at the very beginning. So what is this 92% success rate that gets talked about? Well, the CEDR has done a study, and what they've shown is that 92% of matters that are referred to mediation are successfully resolved, which means people reach agreement. I think it's 74% is on the day, and then there's like another 18% within a week of the mediation happening. So that's like a huge success rate in terms of, and it gives you an idea of how powerful that process actually is. And the reason why it works so well is because in mediation you can have a range of outcomes. You're not limited to the kind of legal remedies. You know, we talked about that kind of win-lose kind of situation. You can include a whole bunch of creative solutions. So you can have apologies, you can have revised roles, you can even have things like joint public statements. So you don't necessarily have to have, it isn't limited in terms of the kinds of outcomes that you can achieve in court. You can customize the terms. So, you know, if there is a payment settlement that needs to be made, you can be very creative about how that payment settlement is achieved. You can do it in terms of an exchange of services. But it's endless. What you can do is only limited to by what you can think of and what you can agree. It's not going to be something that a judge is going to be able to do for you. And in terms of binding, people often say that mediation is not binding. It's just not true. When you reach a settlement agreement, that agreement is committed to paper and it becomes a binding contract when you sign it. The interesting thing is that nothing is until it is committed to paper and signed, it's completely confidential, and it cannot be used against you in later procedures. So nobody in an arbitration or in litigation can say, yes, but in the mediation, this was revealed. It doesn't happen. Mutual cooperation, because it's the disputing parties that craft the settlement and not a judge or an arbitrator, they have already bought into the terms and are invested in the outcome. So basically what they talk about wise agreements and they talk about sustainable agreements. And because you've got parties who have contributed to deciding what that agreement is, there isn't the same kind of resistance or kind of upset that happens after a court case where perhaps you feel that it was a technicality, or your side wasn't, your lawyers didn't successfully convey your side of the argument. You aren't looking for the reasons why you didn't win, basically. Whereas in a mediation, because you've helped craft the agreement, you're invested in the outcome. You have contributed to building that agreement. And last but not least, it also happens to be the insurer's preferred method of dispute resolution as well, for obvious reasons on cost fronts. It's easy, unlike litigation or arbitration. Mediation can be tailored to suit the unique circumstances of a dispute and reducing admin, timing, scope, logistics. All of these things are fairly simple and can be reduced and can reduce the burden on parties that are involved in the dispute. So, but wait, there's more. It works even when it fails. So even when mediation does not result in a final agreement, it will result in a number of upsides. You can still pursue formal proceedings like litigation, arbitration. Because you've been through mediation doesn't stop you from carrying on later on, unless, of course, you've reached agreement, in which case your problem is solved. But what happens in mediation stays in mediation. It can't be used against you later. The scope of contested issues can be narrowed, reducing the cost of future arbitration or litigation. I've talked about that already. And the most importantly, bridges are not burned. A genuine attempt to find mutually agreeable outcome is easy to sell. So this whole idea of the way in which the dispute is dealt with is central to building and maintaining relationships. In a marriage, you have arguments all the time. It doesn't mean that you get divorced, right? So in a commercial relationship, you should be able to have disagreements and find productive ways of resolving those disagreements, which actually strengthen the relationship and help it to move forward. And that's very much what the kind of idea behind mediation is, that this is a process which gives you the best possible chance of helping that relationship to grow stronger, rather than a kind of antagonistic or confrontational approach, adversarial approach, which, once you say you're taking somebody to court, that's never going to be taken as a kind of what did they say, an olive branch, right? You might set the olive branch on fire. And so that's kind of what the facilitative mediation graph looks like in terms of its cumulative risks. And just in case you were wondering, that's to scale. So what happens in mediation? Well, the mediation is broken up into 6 basic phases. The two of the phases happen outside the day of mediation, with the rest happening during the mediation. The pre-mediation, phase 1, that's just when you appoint the mediator. The parties get briefed on the process, what the ground rules are, what the roles are. You confirm who's going to be attending the mediation. So are lawyers going to be there? If there are representatives, do they have a mandate and authority to settle? You can exchange position papers, so you can set out what your sort of case is in a way, and you can exchange that with the other side so that everybody knows going in what the respective positions are. Logistics can be arranged, so what the date and venue are, and the format. So you can have online mediations, that's absolutely possible. Phase 2, the opening. So you arrive at the day of the mediation, you come to the venue, and the mediation generally starts with a joint meeting. So it can be the only time that the 2 parties are in the room together is for this opening, because that is when you basically get to stand up and in person set out what your issues are. And that's quite powerful, because what it means is that if a lot of times people feel that what they want is their day in court, that what's driving this dispute is the fact that they haven't felt heard by the other side. So this actually gives an opportunity for people to have their side of the story heard and to express what they're feeling to the other side in a controlled and safe environment that is confidential as well. So that's the opening, and it's controlled by the mediator, and as I say, it's generally speaking, it can be the only time when the parties are together. So phase 3 is exploration. So this is where you'll break apart, you'll go into separate rooms, and the mediator will go between the two parties, discussing what each side's issues are, how they feel about what the other side's issues are, kind of understanding where did this all come from, how did it start, where did what were your motivations and your needs and interests when you embarked on this project or this kind of relationship which has led to this dispute. So it's very much about understanding what the context is as much as what the individual issues are. And then once you've got a good handle on that, then you start to go into phase 4, which is where you start to look at options generation and negotiation. So in some senses, what this is about is it's about saying, okay, we now know what each other's respective issues are. We've hopefully started to get an understanding of why they're taking the position that they're taking. And then you start to kind of work out, okay, so how can we find solutions that address those issues? And you can basically then present options. The mediator's role is to, as I was mentioning before, do things like reality testing, saying, okay, you're offering X, but how are they going to feel about that? Is that, what do you think their response is going to be? What do you think a reasonable response would be? So the mediator's role is almost like to coach and to act as devil's advocate or to kind of bring the parties closer to each other's kind of positions and an understanding of what the other side's position is. And that often then leads to the exchange of offers and counter offers, with a mediator acting then, the mediator will be the one who will see how the other side will react. They are then very careful. So the way that confidentiality works is that the mediator will never come back into the room, having visited the one party, and reveal anything without the express consent of the other party. So the mediator is never going to share confidential information without your express consent. And so you don't ever have to worry that the mediator is working with the other side to just get a solution, right? The mediator will always work in the interests of a settlement and in the interests of both sides, not that their job is to specifically not take sides, no matter how unreasonable the one side is being, by the way. So, and then phase 5 agreement. So hopefully this is what you get to. You get to a mutually acceptable resolution, which gets drafted. The terms are confirmed and recorded in writing, and then the agreement can be binding if the parties choose. So you can make it an order of court, but then you lose the confidentiality. But it basically has the same standing as any legal contract. Phase 6 is the follow-up, is possibly one of the most underrated bits of the mediation process. But the mediator doesn't just then at the end of the mediation day say, all right, chaps, bye, you've got your agreement, see you later. Thanks for the check. They will follow up. So a mediator will follow up after the mediation is completed and confirm whether people are following the terms of the agreement that has been set out. And often when you've got those complex agreements where there's perhaps terms that are slightly complicated or procedures, they will check in to make sure that, is everybody happy with the way that it's going? So you've always got the possibility to then, it's possible to go back into mediation for a second time if the agreement isn't being stuck to. So when to mediate, the earlier the better. You don't want disputes to start, as Jade's favorite expression, grow horns and wings, right? So you want the thing to be nipped in the bud if you can. Obviously, you have to gauge what is the chemistry going to be like. You don't want to build a small dispute into a big one by saying, oh, let's mediate, right? So there's a balance. But generally speaking, the earlier the better, because there's less at stake. The types of dispute that architects will generally come across: construction contracts, architects' appointments, workplace disputes, other kinds of commercial disputes, and disputes not covered by a contract. This is kind of like your rough proportion. Construction contracts or disputes from construction contracts will be the most common. I would guess that then sort of, architects' appointments are going to be the second. Workplace disputes are always going to be an issue for especially larger practices. And I'll talk a bit more about that in a bit. Other kinds of commercial disputes, suppliers or even other consultants, and disputes not covered by a contract. So the interesting, in fact, I've got a whole bunch of examples, so I'll fast forward to those. So in construction contracts, the key with construction contracts is that a disagreement is only a dispute when properly notified in terms of the contract. So you've got to follow the procedures laid out in the contract, but all of the standard contract forms, whether it's FIDIC, SACE, NEC, JBCC, they all allow for mediation during what they call amicable settlement, that kind of amicable settlement, which they suggest happens before formal proceedings, such as arbitration or adjudication. The timelines for those notifications in the contract will generally leave you enough time to mediate. So you can still follow the letter of the contract and fit mediation in. There's no conflict between incorporating mediation and how those contract procedures work. JBCC edition 5 is actually more mediation friendly than the later editions, with clause 40.5 and 40.6 outlining a binding process for mediation. And SACE backs facilitative mediation as part of the amicable settlement procedures and warns against evaluative models as contradicting the spirit of amicable. So SACE have taken quite a strong view that evaluative mediation, because of that need or that potential to try to influence the mediator's recommendation, that you aren't going to engage in amicable negotiation or amicable settlement. Okay, so examples: delays in completion, payment disputes, defective or non-compliant work, disputes over variations, site access issues, interpretation of contract terms, professional negligence claims, claims for acceleration or disruption, termination of contracts, final account disagreements. All pretty kind of standard disagreement types that you might have in a building contract. Architect's appointments. So PROXA and the SAI client agreement both include provisions for mediation prior to arbitration. And in the FIDIC White Book, clause 43 provides for mediation as part of the dispute resolution process prior to referral to arbitration. FIDIC also allows for non-binding mediator's opinion, but in their guidance, they specifically say that you need to be careful because of that kind of relationship with the mediator's recommendation, and due to its informal and non-enforceable nature. So the problem with the mediator's recommendation is that you can ignore it, right? It isn't mandatory, and it's not binding. So they're saying it's not a kind, you need to treat it with caution, basically. So examples of architectural disputes: disagreements over scope of services, fee disputes, design dissatisfaction, delays blamed on the architects. Who's heard of that one before? Cost overruns, miscommunication or breakdown in trust, allegations of professional negligence, changes to brief, disputes over intellectual property, termination of appointment. All of these are very easily dealt with within a mediation. Workplace disputes. So something that you might not have thought about before. In my own experience, architectural firms are not awesome at HR policies or systems. We tend to grow, a lot of architecture firms will grow from small to large, and they will not necessarily have the experience or the systems in place that are similar to other professional working environments. So it is not a surprise that you can get a lot of issues arising in terms of all the things that are listed here. So employment or HR-related disputes within the practice, interpersonal conflict between colleagues, manager-employee disputes, allegations of bullying or harassment, disagreements over roles and responsibilities, performance or conduct issues, return to work or reintegration after absence, team dysfunction or silo mentality. Mediators are often called in to resolve issues between different parts of a company that just can't communicate. So you can have, perhaps where there's project teams that are competing for resources within the organization, and that starts to become toxic. So how do you get those parties back to be on good terms? And then restructuring and redundancy fallout. So obviously when there's any kind of restructuring or redundancy, that can create problems in terms of how you resolve those processes. And I think the important thing as far as workplace disputes is concerned is that you need to remember that when there is an issue of illegality or criminal conduct, that's not something that can be mediated, right? So if there are criminal issues or if there's illegality, that you need to follow the kind of formal procedures for that. Other kinds of commercial disputes: partnership or practice disputes, fee sharing, referral, joint venture disagreements, IP copyright disputes, not client related, but possibly between architects, disputes with subconsultants or collaborators, landlord-tenant issues related to architectural premises, your offices, disputes over competition results or procurement processes, tendering, billing disputes with suppliers or service providers, disputes arising from public commentary or reputational issues. So it's simply to say, don't think of mediation simply as a tool to deal with contractual disputes. Mediation can help with all kinds of disputes. And then, I'll go and there's a list for disputes not covered by a contract. The one I'm going to look at is family business tensions, because I think often in family businesses, and speaking to other mediators, it's surprising how often family businesses go to mediation, because there are brothers or siblings who maybe inherit the business and then can't agree how to deal with the business now that they are in control. So I'm just going to have a kind of round up that part with another case study, which is based on a real life scenario, and it kind of takes a sort of architectural project and just looks at when would be the right time to look at mediation. So John and Sophia, who rely on word of mouth and a core group of loyal clients, are introduced to Dave by a major repeat client. Dave hires them to design a luxury eco-lodge. He frequently changes the brief, but insists the extra work is just part of the process, and defers any fee discussions until after the project is complete. Reassured by his prompt initial payments and reasonable manner, John and Sophia continue in good faith, hoping for a fair settlement later. The QS provides a cost plan, which excludes some of Dave's additions, but the team is satisfied it's within acceptable 5 to 10% of margin. Plans are submitted and tenders invited. The tender prices returned 30% above expectations, partly due to site remoteness and rising material costs. Dave is furious. His investors, including the referring client, are alarmed. He demands a redesign to meet the original budget or threatens to abandon the project. John and Sophia agree to a partial redesign and again delay pursuing unpaid fees. The revised contract is awarded at 20% above the original estimate, and the start on site is delayed by resubmissions and tender revisions. The project moves forward, with Dave continuing to request changes that increase the team's workload. Still, the lodge is completed on time, on budget, and receives public acclaim. However, Dave refuses to pay the outstanding fees, blaming the delayed start for lost revenue. Though the project is a success in every outward sense, John and Sophia absorb the financial loss, reluctant to pursue legal action for fear of reputational harm and jeopardizing future work. I think there's some stuff in there which we would all recognize from projects we've been involved in. And it kind of shows how in the process, the way that projects work, we are exposed at a number of different places to, I don't want to say exploitation, but to outmaneuvering in terms of commercial negotiation. So there's a number of different places where you could jump in and say, hold on a second, let's talk, right? Let's find a way to disagree and reach a kind of a way forward. As soon as somebody is changing the goalposts and behaving in a way that is not consistent with what you know is going to lead to a positive outcome, you can draw a line and say, can we have a discussion? The way in which I'll come on to next, the way in which you broach mediation is really important, because mediation is not, as we said before, you don't want the fear of blowing the thing up into something bigger than what it already is to stop you from getting a route forward. So how to get to mediation? So it's usually simpler than you think. Just simply suggesting mediation can be a soft way of prompting parties into further discussions. Sometimes the other side doesn't even know that how upset you are, right? We're very good at trying to remain calm and not, losing it because we're worried about how that's going to impact the client relationship. So they may well not even be aware, and they may not be aware because they're just not aware of how strongly you feel. So simply just by raising mediation as a possibility, that can cause them to take a step back and say, oh, I didn't realize. And you might find that that actually might solve things on its own. You haven't threatened to sue them. You've suggested having a conversation in a particular way. And then take advice. If a claim is possible, obviously you have to notify your insurers. If in doubt, speak to a mediator and they can give you advice about whether or not mediation would be appropriate. Choose the right moment. Raise mediation before positions harden or costs escalate. Ideal after initial deadlock, but before formal proceedings start. Frame it constructively. Present mediation as a solution-focused, cost-effective alternative. It's a cheap way to get a quick solution. Emphasize collaboration, confidentiality, and control over the outcome. Stay neutral in tone. Avoid blame or legal threats. Ultimatums that's not the way to get people engaged in a negotiation. Focus on moving forward. Use language like constructive way forward, mutual benefit, or reset the conversation. You can refer to your contract provisions, so you can highlight the mediation clauses in the agreements that you already have. And what that does is it gives legitimacy to your request. You're basically saying, look, in terms of our contract, this is the way we need to deal with this. And you don't then appear weak. It's not like you're saying, we need somebody else to sort out our problem. No, you're following the terms of the contract. Offer a practical next step. Suggest names of credible mediators or a panel, kind of get the ball rolling. Say, look, these are the people that we can go to. You can put it in writing, but it has to be very carefully crafted. And always follow that up with a conversation in a neutral way. Keep the tone solution-orientated and brief. And you should involve legal representatives if needed, but you can do it strategically. Often, these disputes, especially at the early stages, there's not a lot of meat in terms of the kind of legal issues that are involved. But it's good to know where you might be going and what the outcomes might be. What are the consequences if you do have to go the legal route? And the lawyers can also help to frame the mediation as best practice, not as a way of getting concessions. So, oh, look at that, almost 1 minute. What is the mediation clinic? Well, in line with the 92% success rate, fast and cheap, with the CIFA mediation clinic, it's actually cheaper than cheap, it's free. So what we're proposing is a free service at no cost to CIFA or CIFA members for consultations or even half-day mediations. So half-day mediations will be offered on a first-come, first-served basis, along with initial consultations. All of this will happen on a Wednesday afternoon. So Wednesday afternoons will be CIFA mediation day. And basically all of the advice that you get will be confidential. And then obviously the mediations will be arranged through me. If I'm not the right person, so I will be providing the half-day mediations for free. If that isn't suitable, or if you need to go beyond that, conflict dynamics are one of the best, if not the best, providers of mediators in the country, and they will be able to provide you with mediators. Not for free. Marion, not for free. In terms of the key takeaways from today, so ensure facilitative mediation is included in contracts and appointment forms. You want to avoid any ambiguity. Don't get into a situation where somebody says, oh, but I thought we were going to get a mediator's recommendation. That's not what you're looking for. What you're looking for is this process whereby you are both building the solution, not looking to somebody else to solve your problems. Do not waive your legal right to representation at the mediation. So if that clause is included in your appointment forms, strike it out. You want to be able to have an attorney there if you think you need it. For disputes that may lead to claims, check with your insurer first. We all, like, that's the 101, right? So if there is potentially a claim involved, speak to the insurers. They are very much pro mediation, but they may have a panel of mediators that they prefer to use, and they may also want to involve attorneys to guide you through the process. So it's really important to get them on board, and they will also possibly have limits in terms of what they're prepared. What are the parameters of any kind of settlement? The insurers will want to have a kind of a say in that. And just take advice and use the clinic. You can go to my website to book appointments, and we will be releasing the link through CIFA as well. So that is it from me in exactly. So now, Carol, do we have questions? So the panel, I just want to say hello to Marion. It's a bit weird. I don't quite know how to do it. But Adrian is here and Marion is online. So what I'm going to do, Adrian, I'm going to give you a microphone. So if there's a question, just put it on your. Yes, okay. And then I'm going to unmute Marion.
I've unmuted myself.
And I'm going to try and put Marion on the screen.
I just have a question. Will this presentation be shared?
Yes.
Yes.
Yeah. This is okay. There we go. Meeting right now. Let's see if I can get this across. Okay. All right. Oh, come on. There we go. Okay. And of course, the screen is too small. I'm going to have to rely on you for the questions. So, Marion, hello. Are you there, Marion?
Hi,
Yes.
I am here. Yes.
Okay, so the chat.
I'll tell you when there is a question.
Okay. Messages. Sorry, anybody here have a question? No? You guys? No questions? Come on.
You did a good job.
Okay. So Marion's already answered the one question. Yes, Marion is a mediator. Can't believe there's no more questions. Really? Guys, come on. No. Oh, hang on. No. Okay, well,
Now,
yes.
what is the role of the lawyer relative to the mediator?
Okay, so the question is, what is the role of the lawyer relative to the mediator? So the lawyer is very much there to represent and to advise their client in the dispute. And I should have asked Adrian to answer the question.
No problem.
Yeah, Adrian, you go for it.
Yeah, so a lawyer's not always involved, but as Ryan said, preferably you'd want not to have excluded legal representation. And the lawyer, as Ryan says, will be advising you on your rights and so on. And he will know the bigger picture with regard to where that dispute might end up, particularly in an attempt to avoid litigation. The lawyer should preferably assist in playing a facilitative role. You know, I think we get a reputation because our legal system is antagonistic, that perhaps we sort of up the ante every time that there are lawyers in the room. But if the parties are agreed to follow a mediation process, I think the idea is not to increase the antagonism, but to try and see how you can be part of the solution. But you will be giving advice to your client separately. And I think if your client is inclined to achieve a certain resolution to the matter, you shouldn't be steering it away from that. So that would be primarily, I think, the lawyer's role. But you'd really have to get the right lawyer on board, because, you know, 9 times out of 10, what I'm dealing with is, like Ryan showed, on the other side of the spectrum. So we're dealing with the polar opposite to mediation on a daily basis. And yet we are now being compelled in the Gauteng division to where there's enforced or mandatory mediation, which is an odd concept because mediation is normally a voluntary process. And so we need to become more sort of aware of the processes and what needs to be achieved. Because at the end of the day, like Ryan pointed out, if you're going to only litigate, you're going to incur a lot of costs. It's going to take a very long period of time. You're going to be pulled out of your ordinary commercial activities. And so there's real benefit in playing that facilitative role rather than that antagonistic one.
Thank you.
Sorry, Ryan.
Yeah.
So if it's mandatory in the Gauteng division mediation, and you go through the process and one party is unhappy with the results and wants to take it further, does that confidentiality still apply in the next
Absolutely.
phase?
Yeah.
So it's a clean slate.
Correct.
thereafter.
Correct.
I understand.
There is a mediator's report.
Of doing it.
Well, you know, one could say that for any mediation, if you wanted to have that approach towards it. But the idea is to try and reach sort of a consensus and to avoid that dispute and the long-term gravitas of pursuing sort of litigation in court.
There.
Yeah, that's right. I think it's they talk about good faith. I want to actually ask Marion to come in, because one of the kind of principles of mediation is that there has to be a good faith effort on the part of the parties to engage in the process. So one of the jobs of the mediator at the beginning of the process is to make sure that the parties understand that they need to be there in good faith. If they're just there to string the process along, there is literally no point. Right, exactly. But Marion, in terms of, I mean, how mediators view the role of attorneys in the mediation process, I mean, what's your
Yeah, I mean, Adrian made the comment that you have to make sure you have the right attorney. I think you also have to make sure that you have the right mediator. Because one of the skills that a really good mediator has is to work with the attorney and explain to the attorney what their role is in the process and how they can benefit the process. So, I mean, there is a risk that you get an attorney who is really hell-bent in getting to court rather than settling a matter. But at quite an early stage in the process, the mediator needs to try and win that person over, try and educate them about the process. Adrian also mentioned the issue about a report. So in the Gauteng directive, mediators, because this is court annexed or mandated mediation, so it's not purely voluntary, you have to attempt it at least, or have a very good reason not to attempt it. So you as the mediator in these court annexed matters have to have to complete a report at the end of the process, commenting, and there's a template that you have to respond to. So you can't report as you choose to. You have to actually respond to very specific questions. And, one of them is, did the parties act in good faith? Were they there to actually try and resolve the matter or to be constructive? Or did you have to deal with people who were just bloody minded about the process? So mediators are going to have to comment on that, and attorneys who are adversarial will have to, at the end of the day, suffer the wrath of the judges if it's found that they didn't act in good faith, because the implications of not acting in good faith is that costs orders could be brought against parties who do not act in good faith. So yeah, so there are a few sticks that have been brought into this process, which we haven't had to deal with before. It's usually mediators really try and get parties on board, get the attorneys on board, and involve them in specifically what they can bring to the party, because attorneys can bring a lot of risk analysis to the parties. They can become creative about how to develop a settlement that works for them, or at least for their clients. So there's a lot they can actually contribute, and it's going to be very interesting to see, given the move now towards mediation, how quickly they do it. Our understanding, I mean, I was at a meeting recently where we spoke to some of our mediation colleagues in different dispensations where this type of court annexed mediation is legislated as well. And there were people from Italy, people from Ireland, people from the US. I think those were the 3 countries. But all of those mediators said that initially, when the directives came into being, there was a bit of kind of, shaking of feathers and trying to kind of posture, but things settle down quite quickly when people see the benefit of the process and accept that it's there to stay, which I suspect it is now. I hope it is.
Super. Thank you, Marianne. I mean, I see Matthew. Sorry, I know there are a couple of written questions. I will get to those, but I see Matthew's got his hand raised, so I'm gonna.
Thanks. Yes,
Yeah.
I totally agree with you. I mean, I have been down the road once when it took 6 years and it went the legal route, and you're absolutely right how it takes it out of you. I fortunately won that one, and the other guy, I'm sure, really regretted having played with me for 6 years in court. But it absolutely agree with you, it takes it out of you. It really does. And even though I won, okay. This time I've got in my contract, should a dispute arise, the matter will be referred to a single mediator or arbitrator in terms of the South African Association of Arbitration Procedures. Okay, now this current problem I have is a small one. It's simply that this project took so long, and there was dispute about where the boundary of the land was and so on. And eventually the client decided, no, it's a holiday home. I don't need it. I don't want to go with it. and I don't feel like paying the money that I still owe you. So it's a simple case of, yeah, okay. Now, I of course want that money because I did the work. Can and my clause says that the client is free to terminate, but he must pay up to the end of the interrupted work stage. And we had council drawings all ready to submit, but there was this issue about where the boundary was with council. Okay, so it's not actually my issue. Anyway, this guy's overseas. Can I, in terms of this contract, which says what I've just read out to you, obviously mediation makes sense, and how do I use this mediation with the CIFA? I mean, with that in my clause, how do I go? What's the next step?
Yes, so I mean, Marion, you jump in if I go the wrong way, but I think you've got a remedy for mediation. Your next step is to suggest mediation to the other side, right, and to get them to agree to mediation. And you know, as I was kind of setting out, you can then lay the stepping stones, if you like, and say, look, here are the people that I would like to use to mediate. This is what the costs are going to be, this is where I would like to end up. You know, that we come to an agreement. Not to say that, you know, not to say to them, this is how I'm going to win, right? But this is how we're going to have the conversation, basically. And because you potentially, if your client is overseas, you know, you have a multi-jurisdictional. Your professional appointment would have been based on a South African agreement. So
Yes.
the contract law is South African contract law. I don't see any reason why you should have a problem referring it to mediation. And it's simply just a case of getting them on board and saying, this is the way that we're going to go. You know, they can refuse mediation, and then you don't have a choice. You then have to kind of pursue it through other means. But I think it's pretty easy to make the argument that it's in everybody's best interest for a cheap, quick solution rather than a drawn-out, expensive solution. So that's the alternative, right?
If it's in my contract that it says the matter will be referred to a single mediator or arbitrator, can he object to the mediator and say, I'm going straight to arbitration?
Yeah, it does say all.
Yeah.
So there's an option. There's an election that can be, but ordinarily one would try and start with a mediation before you move to arbitration. And I think if there's a dispute, maybe one should just highlight what the benefits are of commencing with a mediation before arbitration. Arbitration, in my experience, will be far more expensive, and it's a lot more formalic. It involves a notice of dispute and then drafting a statement of claim and getting an arbitrator on board that follows a set of rules. Whereas mediation is not within that sort of formalized environment. But your contract does provide an election. It says mediation or. So, you know, if you opt for mediation, I'd need to see your entire contract because there may be various other clauses that govern this, I don't know if there are non-variation clauses and so on in your contract. But if you say mediation, he says arbitration, then you already have a dispute between the two of you.
Okay. Yes. Okay. So, my next step is to write a letter to suggest mediation, and but you said I should put to him the various costs that would be involved in the various options. Said, look here, we can get mediation for this kind of money. Arbitration would cost us this much, and then court we know is going to cost us whatever. You know, I don't know those figures. Where do I get those figures from?
So the you know, if potentially the mediation cost you nothing, because if you did it through the clinic, then you could have a half-day mediation as part of the clinic.
Okay. So that's the first thing I'll suggest to him. Yeah.
So that's the first thing, right? And then in terms of anything else is going to be more expensive. So I'm not, you know,
We're talking it afterwards. That
Yeah, and I think in a way your argument is one, because you don't even have to say what the costs for litigation or arbitration are going to be, because you leave it to his imagination. He's always going to think it's more than what it might be. So
Yes.
I think you're
Okay.
possibly better off just
Yes.
letting it hang, right?
Yes.
Super.
Of course, you know, one wants to wag a big stick and say, yeah, the last guy, he ended up over R1 million more than he
Yeah.
thought he was going to pay. But maybe I should resist doing that.
No, I think that's right. I think that the whole way of approaching mediation is that you want to persuade. I was having this exact same conversation with somebody today. You're into the art of persuasion. You're not into forcing or kind of using power to get somebody to do what you want them to do. You have realized that you are in a situation where you don't have control. So you need to be able to persuade somebody to come into a process, to join you in a process whereby you can work things out together. It's not about you dictating terms. It's not about them dictating terms. It's about getting a joint solution. So as long as you sell it as that, it's very hard for them to disagree. So I think that would be the starting point.
Thanks very much.
Sure.
Yeah.
Thanks, Matthew. Sorry, who else had a hand up? Caroline? Is that
It's like the hand has disappeared, but there's a few questions which Marion answered.
There's a hand up by Matthew Gray.
no, so that was
No, that
Matthew.
wasn't.
Yeah, I think.
Sorry, because I can't see the.
Yeah. Okay.
Let me just. Okay, no, let's just that one, turn that off. And then have.
So the CFA clinic facility available virtually. So yes, it will be. It can be online. And then the other question was, would the outcome of mediation have any weight in the court process? And Marion answered that the settlement. You've got it. You've got it there. Yeah.
There's another hand up there on the.
Oh, okay.
There we go. Yes.
There we go. Oh, sorry, Anvil. Anvil had a hand up.
Hi, everybody. I'm just driving out. I don't know if there's enough time to answer my question. Mine is a little bit different.
Okay, got you've got time, yeah.
A short case study. I'm a business owner. I'm a registered professional, and I recently returned back to South Africa. And I had a notion of as an employer going back to becoming an employee. So I applied for a job at a specific architecture firm that was recently registered, doing work on a probationary period for a week. I signed a contract of employment that was based on the BCEA, the Basic Conditions of Employment Act of South Africa, as well as the Labour Relations Act. My probationary, I signed for a specific amount of money, very, very low. But look, coming back to South Africa, I needed some cash flow. But prior to signing the contract, I had an engagement with the employer in terms of would they allow some room for me to move, to wiggle and learn the systems and the office protocol, whereby the employer said that they do not have office protocol and the company is quite new. So after a week of working and spending long hours trying to navigate around 4 different projects simultaneously and learning the system models, maybe Revit models that other technologists also worked on, it was quite strenuous. So after a week of work, the employer called me in and gave me a formal written warning for not completing work on time, and there was a whole list of things. To my dismay, I then responded in an email and terminated the contract with immediate effect. So she wanted to pay me pro rata, and I sent her an invoice where I based my fees on a timely based fee as per the calculations in the guideline for professional fees. So my number ended up being way more than her number that she, with her calculations that she gathered from ChatGPT, way more. So there is a potential dispute that might arise. I should also say that there, in terms of legalities, if we should move to some form of mediation, I can beat her on some forms of technicality. The contract that I signed was not signed by witnesses, even though the contract, there's a likeness of mind that the contract would be valid or validated by a court. But I'm just concerned that there will be a dispute in terms of the numbers, whereby I added my disbursements as per the Department of Public Works and as per the government gazette, what is stipulated as per me being a professional, registered professional. So what do I do in this instance? Oh, I should also say a footnote that the employer is not a registered professional, and what the employer does is they employ registered professionals to carry out architectural work and sign it off, submit it to council. So we would carry the responsibility of the works that are done, but the employer itself is not a registered professional. So there's that as well. What
Yeah,
I do? Yeah. So any advice?
No, it's a super interesting situation, and I think it's one which is like probably a lot more common than what people think. So you've got all of those ingredients that we went through in terms of there's some contractual issues, there's some non-contractual issues. I think the key thing though is that what I was reading a book about construction mediation, and the guy who was a very experienced mediator, he said, you have to remember that a mediated outcome is not necessarily it's not necessarily what's right or what's wrong. It's what's commercially acceptable to both sides. So I think that when you're looking at I think at the moment you're kind of constructing your case, right? You're trying to establish what your position is and what your rights are, and that's helpful in terms of kind of setting a baseline for yourself. But I think it's always remember that a mediation is essentially a negotiation. So the mediation provides you with a platform to negotiate a settlement, and in order to get to that platform, the other side needs to feel that they've got something to gain by entering into that negotiation process with you. So in your circumstances, there are, if it's a labor dispute, potentially there is a kind of a formal process in terms of tribunal and that kind of process that you can follow. But you can still go to mediation before that, right? So mediation can happen at any time, and you can elect to, you can offer to mediate the dispute, or sorry, you can offer to have the dispute mediated, and then depending on how you propose it to them will determine on whether or not they accept your invitation to have the matter mediated. So it's really up to you and them to decide on A, whether to mediate, and then B, if you are going to mediate, who's the best person to mediate the matter. And that might come down to cost, it might come down to convenience, what's the location, or if it's online or something like that. So I think the advice that I would give you, and I'm open to both Adrian and Marion to kind of follow up on this, is to engage with them first and say, look, we have a dispute, we are in dispute. I would like to resolve the dispute through mediation because that makes the most sense, and here are the advantages and etc. And it's you're not prejudicing your rights to go to a formal dispute resolution process in due course. So I think, you know, and for a bunch of reasons for them, what it sounds like is that there might be some reputational damage, because if you do go into a formal process where there's litigation and it comes out in the open that they might be operating in a way that is not strictly in accordance with best practice or whatever, that's not something they want to have out in the open. So there's going to be motivation for them to want to keep it confidential. And so, you know, they've got nothing to lose by going to mediation either, especially if the mediation doesn't cost them anything. So I think, you know, I think yours is a kind of a hybrid between, Marion, correct me if I'm wrong, but it's kind of a hybrid between a workplace mediation issue, because I think from what you're saying and describing, there's kind of, you know, work culture and employment ethics going on. But then there's also a commercial side, because you do have an employment contract. So there will be terms and conditions, which, whether or not they're, you know, correctly worded or how they're implemented and you know, whether the correct procedures were followed, that's all part of that conversation. But I think ultimately remember that the mediation is a negotiation, it's not about getting somebody, i.e. the mediator, to say they're wrong and you're right, right?
Yeah. Thank you.
Super. So I think, are there any outstanding, has anybody got any outstanding questions that haven't been answered by Marion, who's been furiously typing away in the chat? If you maybe just raise your hand if your question hasn't been answered, that's just easier for us, because I think
access to the clinic. I mean, I think maybe
okay.
practical details.
Yeah, so is the CIFA clinic facility available virtually? Absolutely. You don't have to come to Cape Town. So look, I think in-person mediation and online mediation, if it's done well, it can have a positive result as well. So, you know, it doesn't, you don't need to be in person. It can be virtual. The key thing is to sign up for the appointment. So on my website, there is a place where you can book an appointment, but I'll do a follow-up for this, giving you a kind of a step-by-step. If you are interested in taking advantage of the clinic, then you can, it'll be fairly simple and straightforward how to do that. I hope that answers the question. So it is 7:30. If nobody's got any other questions, I just want to also say thank you to CIFA and to Zulfa for organizing and hosting the event. And this won't be standalone. I do plan to repeat this later on, because I think there is absolutely scope for, I'm sure there are more people who would benefit from this kind of information than were online today. So I will make the talk available online if you want to share it. And, you know, there's also, you know, if you're interested in training as a mediator, Marion is the person to speak to. I can forward on Marion's details. And if you're interested, if you become a trained mediator and you're interested in joining the clinic, then please, you know, there's always room for more mediators. So that's it. Thank you very much.